I've spoken to you before about issues of liability and damages and sources of recovery on personal injury cases. So today I'd like to talk a little bit about defenses, and specifically what I think are defense fails. When you present a case in trial, the judge and the jury don't just hear your side of it. They hear the other side as well. They will hear the defenses, the reasons why it's not the other person's fault. Some of the defenses that we run into are interesting. Some are even comical. But I'd like to share a few of the defenses that I've heard in depositions and trials. On liability, we can say, it wasn't my fault. It wasn't my fault because the sun was in my eyes. I think most of us would agree that if the sun is in your eyes, you probably shouldn't proceed. It wasn't my fault because my brakes failed. Well, usually they work better when you press on them. And the brake is the one on the left. The gas is the one on the right. Also, if you don't maintain your brakes and they fail, you still have responsibility. I had a case where the testimony was, my boss said that I have to drive the truck as it is. And this was a problem because the connection between the truck and the trailer, the brake connection was disconnected. And the driver knew this. And he told the boss about it, and the boss said, you have to drive the truck the way it is. And so he got on the freeway, managed to get off of the freeway, and ran up to a few stop lights, was able to stop, but every time it took him longer as the brakes got weaker and weaker in the cab, and the trailer wasn't helping. My client was stopped at a red light, and so he wasn't able to stop and slammed into him. But he had to drive because his boss said he had to drive it the way it was.
It's not my fault.
No. I had to stop my rig on the side of the highway. More and more often, you'll see big rigs stopped on the shoulder. And they're allowed to do that if there's an emergency. But if there's not an emergency, if they're just catching 40 winks, or if they're deciding to check something out in the cab, they should not be there. And a lot of people are running into the rear end of these rigs parked on the side of the road. So, was it really an emergency? That's the question. And if it isn't, they shouldn't be there. They should make it off to the off-ramp. I didn't see the motorcycle because it was too close. I didn't really understand what they meant by that. And with motorcycles, you should understand that there's always a headlight on. All modern motorcycles are designed so that as soon as you turn on the ignition, the headlight is on. You don't have a switch to turn that off. You can go high beam or low beam, but you can't turn it off. So unless the light is broken, the headlight's going to be on, and you should be able to see the motorcycles. The most common motorcycle accidents I see in my practice are people making left turns in front of motorcyclists. Don't understand why that happens, but it happens an awful lot. It's not my fault because he was in my blind spot. Okay, well, you're supposed to look. You have mirrors on the side and a mirror in the center, and you can turn your head, and you can look and see before you change lanes. I had to change lanes. I didn't want to miss my exit. You see this all the time. All of us have seen people who have changed lanes 2 or 3 lanes over to get off the off-ramp, or even just to turn on a side street. It's much simpler just to go to the next exit. Just go to the next exit and come back, or go down the street and make a U-turn if you have to. But so many people are impatient and they don't really check before they turn, and they change lanes. Premises liability cases, slip and fall cases. It's not our fault because we put up a wet floor sign. Well, that's good. I mean, I encourage people to put up wet floor signs. It's helpful. But it's not helpful if they're not at the location where the floor is wet. So if you put up a wet floor sign at the entrance and you're mopping at the back of the store and there are no signs there, when someone comes through the door in the back and slips and falls, the sign has not been effective. It's not an effective defense. Or if you leave that sign up 24/7, if it's always there, That's not an effective warning because people learn to ignore it. Every time they come in the store, that same sign is sitting there, whether the floor is wet or dry. It's usually dry, so they ignore it. It's not effective. On injuries, there are certain defenses we come up with. All of the claimed injuries are pre-existing. We see this an awful lot. And the doctors can tell you that over a certain age, probably 20 or 25, all of us are going to develop some degenerative conditions in our spine. But that doesn't mean that you have any symptoms from it. But we get this defense all the time where they say, well, you had the same condition before the accident that you had after the accident, and so the accident didn't cause any problem. Never mind the fact that you didn't hurt before, and after the accident, now you hurt. On TBI cases, traumatic brain injury cases, we get this a lot. No, it's not really TBI. It's your client's female, so it's a borderline personality disorder. That's what she has, because that mostly affects females. Or a somatoform disorder. It has nothing at all to do with a traumatic brain injury. There are tests that can be done, and doctors will testify about traumatic brain injuries. Malingering. This is a defense that they will almost always come up with. You're looking for something for nothing. You're malingering. It's not, the injuries aren't really real. And there are neuropsychologists that will do testing, and many of the defense neuropsychologists will test specifically for malingering. That's the main reason why they do the testing. Of course, we have neuropsychologists and neuropsychiatrists that we use as well who can say, no, that's not the case. This is a traumatic brain injury, and this is how it presents. Another defense fail on damages. We always get the argument, the plaintiff thinks that she just won the lottery. Never mind, we ran her over with a truck. She thinks she won the lottery, and that's what it's all about. Or the plaintiff will never get that surgery that her doctor says that she needs, so why should we pay for it? We just don't think she's going to get it. Or the future medicals, if she has medical expenses on down the road for surgery or things like that, they're going to be covered. They'll be covered by Medicare or Medi-Cal or anybody but us. We think the taxpayers should pay for this. We don't think we should be responsible for it. Or the plaintiff could return to work at any time. There's no reason why she can't work. Well, we have vocational rehabilitation experts that can say, this person in her condition with the residual injuries from this accident can only do these types of jobs. Where before the accident, she was capable of doing many types of jobs that could make her a lot more money. So her earning capacity in the future is compromised. And finally, if you have an elderly client, they're going to argue, we should not have to pay for future pain and suffering damages because, well, she's not going to live that long. She's old. Why should we have to pay for that? But I think we know that whatever is scarce is valuable. And the last years of life, I think, are always the most precious. And so compensation should be there. So these are some of the things that I've run into in my practice. And if you have any questions, I'll be happy to answer them.
Did you talk about the end of life to this group specifically?
Just you, Dennis.
Thank you.
Yeah. Well, for some of us, it's no longer relevant.
So,
Jack?
these are things you've encountered personally in your practice. It sounds like it's a case of expert against expert, but is there more to it than that?
Well, the individuals are what really carry the day, because if you have a good client, it doesn't really matter what an expert says. If the client comes across well and is believable and trustworthy, I think a judge and jury are going to agree with them about their injuries. Oftentimes when you have battles of experts, they tend to cancel each other out, because people will know that this is a paid expert for this side, and this is a paid expert for that side, and they make it difficult to decide between them. If one expert is particularly good and one is not, obviously that tilts the scale. But in most cases, I think the most important person is the client. If the client comes across well and the client gives the best testimony that they're capable of giving and they're believable, I think the client wins.
And sitting in a wheelchair missing 3 limbs never hurts.
Sounds painful.
Yes, Doctor?
A really tough case, I'm sure you know, is a pre-existing. Is that the same thing that Sean is saying? In that case, it comes down to expert versus expert? Because it's very hard, as you know,
It can.
to prove pre-existing.
Sure. Well, pre-existing is a double-edged sword because on the one side, you're going to say, well, this problem pre-existed, so we shouldn't have to pay for it. On the other side, you say, well, look, this made this person much more susceptible to future harm, particularly if you have a minor impact case where you wouldn't expect someone to be harmed. If they have a pre-existing condition that makes them more easily harmed from trauma, that helps your case. So again, it's a double-edged sword.
It's the eggshell claimant.
Yes, the eggshell claimant. Right. Okay, thank you very much.